We have one other bill that needs to get done today. Therefore, I will call for a vote on this bill probably around 1:15, which is 30 minutes from now. So I will ask if Representative Waddell or Representative Ivor or Representative Fresnel or Representative Horn, who's not here right now, if y'all would just like to make any other comments. I'm sorry, correct, Ms. Representative Horn. Would you like to make any further comments other than what you presented last time? You would, before you want to
make a quick comment. And hopefully we get this voted before 1. Thank you, Mr. Chair, Madam Chair, and members of the committee. This bill, I think we heard it last week, or we heard some discussion on this bill last week. It's a simple bill. It's not controversial. What I'd like to do is hopefully this will start to allow parents who've lost their children by death, mental incapacity, or incarceration to petition the court for visitation of the children of their child. When you have lost a child, it's traumatic enough, but when for whatever reason you have lost the contact you may have had with this grandchild, it's devastating. I got involved in this bill because I have a friend, and my friend is here today, that went through exactly what I just described. 413 will allow the estranged grandparent or grandparents in these cases the chance to petition the court for visitation. And we have gone through the family law section of the bar to try to get everybody to the table. So they are not in opposition to this. And I'll turn it back over to Chair and take any questions.
Is there any member of the committee that has any questions or comments for either Representatives Waddell, Ivor, Horn, or Fresnel concerning this bill?
I have comments on it.
Representative Stevens.
Thank you, Mr. Chair. Ladies and gentlemen of the committee, most of you know that I do primarily family law. That's what I've done for 28 years. So I know a lot about this particular issue. There are currently ways that grandparents can get visitations in very limited circumstances. North Carolina has a law for that. If there is a lawsuit pending between the parents, there's controversy. Grandparents can seek to intervene. If the parents are acting inconsistent with their constitutionally protected rights, they can intervene. That means they're not making sure they're fed. It means they're not making sure they've left them somewhere. They drop them from pillar to post. They're not doing what they should do as parents. Grandparents can intervene. If a child has been adopted by a step-parent, grandparents can get visitation. But for the most part, the Supreme Court's been very clear. The 14th Amendment says parents have the fundamental right to decide with whom their children associate and what they do. The Supreme Court's been very, very clear about that, and without a very, very compelling reason, the state should not interfere. I believe this is an unconstitutional bill. I believe it will not survive if we pass it. The U.S. Supreme Court has ruled on this matter. Now, this particular bill doesn't just go to someone where the child, the one parent has deceased. It goes also to people where one parent's been incarcerated for whatever reason. It goes to mental and physical incapacity. In those cases, the parent can still petition for visitation. As a parent, as an attorney, if I've got grandparents who are wanting to visit, I say, will your child petition for visitation? Will your child? Because then you can get involved. You can clearly get involved. From physical incapacity, that parent can still file a lawsuit, grandparents get involved. Mental incapacity, a guardian can be appointed and petition for visitation and custody rights, and the grandparents can get involved. Incarceration, they're allowed to get writs and come up, they do that all the time. So, but it takes parental involvement. Now, on the death situation. Death is always a very hard time, especially on a child. There's that much controversy already going in the house, and then grandparents are going to come in and file a lawsuit seeking to visit their grandchildren. And they have to show some compelling reason. The reasons that are set forth down here are not compelling. The fact that they won't participate in mediation. They're not required by law to participate in mediation, not unless there's an actual custody action pending. And if they are, what's good faith? There's no requirement that they allow their child to visit. This bill also has nothing in here that says the court's supposed to take a superior look, and I'll read you the law from Troxel versus Granville, that the court, there's a presumption that if parents are fit, and they always act in their child's best interest. There is normally no reason for the state to inject itself into the private realm of the family to further question the fit parent's ability to make the best decisions regarding their children. That is the United States Supreme Court. In the United States Supreme Court case, that involved the death of the mother, and the grandparents were getting visitation. And the court said, you've way overreached your bounds. Now, I know a lot of you've been appealed to emotionally, and I'm really trying to appeal to you from a legal perspective. Our job is to pass a law that will pass muster. We all took an oath and swore that we would uphold the Constitution of the state of North Carolina and the Constitution of the United States. We're not going to do it if we pass this law. Now, I'll give you the personal situation. My brother committed suicide. He and his wife were getting ready to separate anyway, and he got very depressed and he committed suicide. And honestly, at the time he committed suicide, my parents were in the house with him, as was his 12-year-old son. They were close to all of the children. We were very close to them. My father fought to try to get visitation. So I had to explain to him, legally you probably can't do that. But he fought, and he fought endlessly to try to get visitation. But I'll be honest, if I were the parent, I wouldn't have given him visitation. If he were as upset and irrational as he was, I wouldn't have given him visitation. Now, my mother was a whole different story, but she understood it wasn't her place to interfere with that parent's rights. Reality was, eventually the children wanted to see us. There was enough of the relationship, they were able to compel upon their mother, and we ultimately saw them. And that's how this stuff is supposed to play out. Because when you come into a court ready to battle in this manner, you do much more damage to a family than you fix. It is a situation where, if you look at this statute, let me get back to the bill. It says the willingness of the grandparent to encourage a close relationship between the child and the child's parent. What parent? The parent you're living with, or the parent who's just died, incarcerated, or has mental and physical capacity? It doesn't tell us. And that should not be a compelling reason. The willingness of that parent, that grandparent, to uphold that parent should not and is not a compelling reason. The willingness of the child to develop a relationship with the grandparent if the court determines the child's of legal age. I mean, that would be important if you met the compelling step to get over it to begin with. This one is completely out of the ordinary or out of the extreme. The reasonableness or lack of reasonableness of the parent who has custody in allowing, restricting, or denying visitation to begin with. Again, it's the parent's right. It's a fundamental constitutional right to that parent to do this. Whether the parties have participated or attempted to participate in good faith in mediation. Well, you can't get to mediation until you've got the lawsuit. Then the court has to order it there. And what is good faith participation in mediation? I don't have to give you visitation because I'm the parent. So what's good faith in that mediation? And then it says any other factor that deems it relevant. That's nothing there that sets forth a compelling reason to allow grandparents to intrude into fundamental rights of parents. The compelling reasons recognized by the court are those I've just set out. You act inconsistent with your constitutionally protected rights by court. That's unfit, that's neglect, that's dropping off. You get involved in a family that's already fighting. You don't create new boundaries or new problems for the children. The adoption by a step parent where the natural biological parents already have a good relationship with them. This goes entirely too far. The North Carolina Family Policy Council has specifically opposed this bill because it is an intrusion by the state into the family. The Bar Association, Family Law Section, tried to work with this committee, tried to work with these groups to talk about limiting, and they removed 5 of those reasons, and the rest were not compelling. They are not in favor of this bill. They promised they would not speak against it because the group tried to work with them. But most people who do family law are not going to be in favor of this bill. It's very, very unconstitutional, and we need to do our statutory constitutional duty and vote this bill down.
So, Mr. Marshall, would you close the door, please? Thank you.
Yes.
Thank you, Representative Steve. Representative Speciale.
There's a lot of sad things that go on in life, especially within family units. But there's a lot of things that you cannot fix legislatively, that the government cannot get involved in, and this happens to be one of them. There's all kinds of stories of things where kids don't get to see their I have 8 grandchildren myself, and it would rip my heart out if I couldn't see them. And I would like to think it would rip their heart out if they couldn't see me. But the bottom line is I would have to depend on the fact that if their parents, either my kids or my in-laws, chose not to have a relationship with me, I would be waiting for the time when those kids turned old enough to where they could make their own decision, and I would have a relationship with them then. We cannot legislate. I think I have to agree with the last speaker that this bill is unconstitutional to do this. We don't have the constitutional authority to legislate what parents can do with regards to their kids like that. And there are some reasons why children, there are a lot of parents, and I know some of them, who don't want their children to have a relationship with their parents for various reasons. Maybe they were molested as children, they never said anything, but they just made a promise to themselves that their kids would never be there. I don't know, people have their own reasons, but the point is, as a parent, I would not want the state telling me what I had to do, who I was forced to allow to visit my kids, and I understand, again, I understand the heart-wrenching thing on part of the grandparents that are here advocating for this, but I do believe that if we were to pass this bill, what we would be doing would be illegal, and it certainly would be against the standards of liberty that we are tasked with upholding. We are here to protect the rights of the people, and the rights of the parents is part of that, and the parents have the right to determine who should or should not spend time with their children.
Thank you, Representative Eanscope.
Thank you, Mr. Chairman. I historically have been a no vote on this bill. I'm going to vote yes on this bill because it's the narrowest version I've seen. I do agree that there are problems in this. I agree with Representative Speciale that from my perspective, the danger is that you are drawing an innocent child between two emotionally engaged adult groups, and I think that that's a very difficult situation. I understand that there are some times when there are situations, and I think that this bill would address one of them, when there's a legitimate reason. So I'm trusting that courts would be very careful with this as they apply it.
Thank you, Representative Horn.
Thank you, Mr. Chairman. Part of the reason that, well, first of all, yes, I am a grandparent. I'm very fortunate. I have a great relationship with I only have 7 grandchildren. Certainly, like a lot of people, I'm very much aware of folks that have very difficult circumstances in their family. And I'm struck, frankly, that all the changes that have occurred in our society in the last 20 years, to the point, and particularly an incredible number of grandparents raising their grandchildren and then having those children oftentimes pulled out from under them, or contact denied because a parent got religion, so to speak, and says, okay, I want back, and the parental rights trumps. When in fact that parent, in my view, not a legal view, abdicated those parental rights, and now because they might be able to get state money, they might, etc., they've suddenly reappeared on the scene for who knows how long. I'm struck in the bill that the word may dominates in this bill with regard to the action. Not will, not shall, but may. Thereby giving the judge, and in spite of rumors to the contrary, I've got pretty good faith in most of our judges. I can't imagine being a judge in a family court situation. And I think that by and large they do a very good job. And to me, this bill gives them some guidelines to consider. It doesn't say to the court, you will or you shall, and if it did, that would, in my view, be unconstitutional. I'm not a lawyer. Thank goodness. No, maybe sadly, I can make more money. So, given the fact that it seems to me, the intent of this bill is to give some guidance and give some opportunity for a grandparent to be heard. And I'll conclude with this concept of standing. Who has standing in a courtroom? And I know although again, I'm trying to interpret something I really don't know a lot about, but I've heard this way too much, is so-and-so can't testify because they have no standing. The grandparents' rights are not recognized. I think it's the intent of this bill to create standing for grandparents so we can say, hey, I should have something to say about this. I present stability, I present responsibility, and accountability. And that's the reason that I participated in this, and I support it.
Representative Baskerville.
Thank you, Mr. Chairman. I appreciate the comments from all of my colleagues. Bashali's on point. You cannot legislate everything, a solution to everything. I agree with Representative Stevens, I really do. I do think there's a very good argument to be made that this bill is unconstitutional. Now, that won't be the first bill that we pass out of this body.
And I can guarantee you won't be the last.
As long as it's not the next.
But, you know, these stories, how can you hear these stories and not try to do what you can do? Not try to put some sort of legislation together to try to stop another story. Very emotional story, you're right. It was emotional arguments, but they're compelling. And so I do think there's some issues with the bill, but I'm willing to go out there and support it, and give these grandparents a shot in court. If it's unconstitutional, it'll get shut down. But I'm willing to give it a shot. Thank you.
Thank you, Representative.
Yeah, I'd just like to say I've been practicing law, domestic law, for almost 40 years. Whether it's unconstitutional or not, I don't know. I mean, it could be, it could not be. But we have a problem, and one of the ways we solve this problem is to continue to put cases in front of the Supreme Court and let them tell us what the law is. They're not going to tell us the law just because we ask them to. It's only going to get there if the case gets there. So it's all a learning process for both of us, but it is a serious problem for kids and parents, and if there is acrimony in these situations. That's what courts are there for, is to resolve that.
Thank you, Representative Speciale.
One of our colleagues here mentioned about faith in the judges, and I have faith in our judicial system as well. But let me remind you of Thomas Jefferson's words, let me hear no more about confidence in man, but let us bind him down by the chains of the Constitution. And that's our responsibility. We're here to make sure that what we're passing is legitimate, that what we're passing is legal, that it will pass a constitutional muster, because again, as heart-wrenching as this is, we don't just represent grandparents here, we represent all the citizens of this state, and what we're doing, what we do when we pass this law, whether we pass this or we don't, it must pass muster with the law and with the Constitution and with the people of this state. And to hear people say, well, you know, we passed them before and this and that, that is, we just can't go down that road. This is clearly not an area where government needs to be, and when we talk about reliance on the courts for making these decisions, the courts have made the decisions, and not only in North Carolina, but the Supreme Court has made the decisions that the parents have the right to determine these things. And so what we would be doing, again, is opening up an area unconstitutionally that has already been opened up, that has already been clarified, and has already been closed as far as the law is concerned. I'm not a lawyer, but I'm smart enough to know that to do anything other than give this bill an unfavorable motion would be simply unconstitutional. And I'd like to make a motion that this bill, an unfavorable motion on this bill.
You'll hold that thought, please. Representative Steve Cleveland.
Thank you, Mr. Chairman. I feel compelled to report that I have 9 grandchildren and 7 great-grandchildren. There's already a process for grandparents to pursue. And we hear the horrific reports of problems out there. But I would venture to say for every horrific one we get, there's 1,000, 1,500 or more out there that don't have these problems. And these folks that have these problems, they have them for a reason. And we should not legislate to a parent that they must abrogate their responsibility in bringing up their children. And that's, I think, what this bill is doing. So I would encourage this to be.
Thank you, Representative Stevens.
Thank you, and I wanted to go back and reference several things that people have said. We're happy abdicating our constitutional authority. We passed unconstitutional bills, let's just do it again. Representative Warren talked about grandparents who are raising their grandchildren right now. That gives them the standing because those parents are acting inconsistent with their constitutionally protected rights. You still have the right to get in there and petition for custody and or at least visitation. You talked about use of the word may versus shall. May is the only word that could be used because the court determines some custody, but we can't bind their hands to say you have to give grandparents visitation. We can't bind their hands and say you have to give a parent visitation. The court has to look at what the facts are. So you're talking about trying to give grandparents standing, and you're trying to give them a constitutional standing where none exist. You're talking about abrogating parents' responsibility, their constitutional protections, they're good parents. We talked about stories, all the horror stories we hear. Let me tell you the stories we haven't heard, because grandparent visitation bills come up every year for 15 years, 18, however long, every term it comes up. And the stories we haven't heard this time, because we haven't been moving the bill as much, is the impact on the parents. The parents, and I know there's at least one out there right now, whose grandparent kept threatening to take custody and visitation and was very, very much undermining situations. There's two sides to every story. Just like my father's story. He loved his grandchildren, he wanted to see them. He was the namesake of the deceased son. There was all the emotional stories I can put there, but he was also behaving atrociously. Atrociously. Whether she knew it or whether she not, the mother, he was behaving atrociously. It might have been good for the grandson to be with him. The grandson needed to have that attachment to the family. But that was not the controlling factor. The controlling factor is what mom thinks ought to be done with the child. And if this committee is going to choose to abdicate its authority on the constitutional issues, I'm going to recommend the rules chair take a look at this and perhaps send it to the constitutional committee. Because we are at the family law committee. We are talking about family law policy. We as a family law group think it's good to bring all those family people in, but that's probably not our constitutional duty here. So that would probably be my recommendation, assuming it gets out of this committee.
Thank you. Is there any other member of the committee that has any questions or comments concerning the proposed bill? Hearing none. Representative Isla, would you like to speak as a sponsor of the bill?
Thank you, Mr. Chairman. Fun to have the floor. Thank you, Mr. Chairman. Everything you've heard about custody has nothing to do with this bill. You cannot go to visitation unless you're already in custody battle. The grandparents have no visitation rights until this bill is passed. To go for visitation only, not custody has nothing to do with this. Also, the Constitution has separation of powers. We don't decide what's constitutional, the courts decide. So therefore, we do our job as legislators. The courts can decide whether or not it's constitutional, and to compare it to another case, which involve other factors, you know, logically, I'm not an attorney, but logically it doesn't, again, they can challenge this law if they want to. That's all I want to say, Mr. Chairman.
Thanks, sir. Representative Stevens.
All I want to say is visitation is a form of custody. Visitation is.
All right. I understand this is a very
I don't know.
passionate, I understand this is a very passionate issue. I think we're going to feel strongly both ways. We show each other respect. So when somebody says something you may not agree to, please be quiet, because I'm sure if you speak later and somebody may not agree with you, they'll show you the same respect. So thank you. Yes, ma'am.
And I don't know how many of these people who were trying to speak out were lawyers, but visitation is merely a form of custody. It is. And we do have an obligation to follow the Constitution, and I've showed you the Supreme Court cases that say the Constitution says you don't take away a parent's fundamental right. Now, at least, again, 2 of the subsections set in here are where both parents are still around and are not in a custody battle. That is physical and mental incapacity and incarceration. The parents are still around and the parents can participate in this lawsuit. You're really opening a Pandora's box.
Thank you. I want to take a vote at 1:15, but we have until 1:50 before we have to surrender the room. I know we have one bill after this, so we'll allow some latitude. Yes, sir, Representative Bell.
Mr. Chairman, there are other committee meetings that members need to go to. And as well, so if we could take a vote, I would greatly appreciate it. Thank you, sir.
What I want to do is show a little latitude. Now, we allowed time last time that we discussed this for the public to speak. So I would ask, is anybody from the public who has a burning desire to address the board? We all know why you're here. We all know you're going to be in favor of the bill, so that goes without saying. But I'm not going to open this up for a long discussion. So if someone would like to speak that was not here last time and did not speak last time, I'll allow maybe 3 people to talk at the most 2 minutes apiece, please. If one person, if the first person that wanted to speak, they'll come forward, please. And I'll need you to identify yourself for the record, and please limit your comments to 2 minutes.
Good afternoon. My name is Kathy Hartall. I'm here again, as I have been for 18 years, as a parent extremely opposed to the concept of further expanding grandparent visitation. Now, my children were very affected by this. 18 years ago, I had one 2-year-old. That 2-year-old is 20 years old, and I have another child who is almost 17 years old. This has been a threat over the heads of parents for 18 years in the state of North Carolina. It is time that it stopped. There are the same stories on the side of parents as there are what I'm sure are very nice people here. You're not hearing our stories because we don't want to air our laundry in these buildings, and we don't want to air our laundry in a court building. It's just that simple. Sad, sad situations on both sides. So why am I still here, even though my children are almost 17 and are almost 20 years old? I am still here for the parents who can't be here today. I am still here for the parents who know this is wrong. I am still here for the parents who knows that this is unconstitutional. And I am here for those children. It has been said time and time again, do it for the children. Keep our families together. The exact same thing could be said on the flip side of this issue. The most important thing I'd like to say to you today is this is a judicial committee. Good policy is not made based on emotion, and emotion has no place in a judicial committee. Please make this decision based on the law. Thank you.
Thank you, ma'am. The second person will ask you to allow one more after that, please.
Yes, my name is Sandy Wicker. My son, he was diagnosed at 33 with Ewing sarcoma. He passed away at 34. He had, at that time, a 3-year-old son. He's now 5. And we had kept my grandson since he was born. You know, every week, you know, whatever they needed to do. Anyway, now we haven't had but maybe 1 or 2 visitations with him since 3 years of age when my son passed away. you know, I don't know, I'm speaking, I guess, for his rights, because he's obviously not old enough to speak for himself, but just like I asked Mr. Royal the other day when we were discussing this whole situation with him, what am I supposed, you know, I was asking him for an answer. Just exactly what am I supposed to tell my grandson when we talk on the phone, he says, I love you, I want to come see you, but my mom says I can't. What am I supposed to tell him? Can all whole judicial committee give me an answer for that? He doesn't understand. You know, there's answers for everything else. Where are my rights? Where are his rights to have one? Thank you.
Now, at the present time, I understand, Representative Speciale, you had a motion that you want to make. The motion then withdrawn. The floor is now open for any member of the committee to make a motion if so desire. Representative Zachary.
I make a motion for favorable report.
All right, there's a motion for a favorable report. I'm going to call for the ayes and the nays. So, Madam Clerk, if you will please do that.
Representatives Baskerville,
Aye.
Turner, Bell,
No.
Brown, Cleveland, Farmer Butterfield,
Yes.
Horn,
Yes.
Insco,
Yes.
Speciale,
No.
Zachary.
Aye.
Davis,
I vote yes.
Stevens.
The vote was 6 in favor, 6 opposed, therefore it fails because it was a tie.
That is so
I thank y'all for coming. The next item on the agenda is House Bill 115. I will turn the gavel over to Mrs. Stevens.